Welcome, ladies and gentlemen. My name is Roland Petz, Executive Director of the Australian Chamber of Commerce in South Korea. It's my absolute pleasure to welcome you to today's latest webinar, Update on the Serious Accident Punishment Act, also known as SAPA, to shed light on this very important topic and how it can impact your business and the liability of CEOs in the business community. I am joined by two experts from Shin Kim, Michael Chang and Anthony Chang. Delving deeper into the topic, I'd like to now hand it over to Michael Chang, who's an AustCham board member and senior foreign attorney and partner at Shin Kim. Michael, over to you. Thank you. Cool.
Thanks, Pets. Good afternoon, everyone. Nice to see everyone who's taken the time to join. Thank you. It's an important topic, and no doubt many of you have heard much of it, or at least some of this topic before. It is important, and we thought that it would give the opportunity for members of AustCham to hear from one of our experts. Anthony Chang and I are partners at the firm. We've known each other for almost 30 years. He started his career at the Samsung Group Chairman's office as a lawyer, and then he moved back to the States. He's a US lawyer. He's worked in Boston, New York, returned to Seoul, then spent many years with Philip Morris in-house, was in the APAC legal department for many years in Hong Kong, and then has now has been with us now for almost 2 years. He's in the Labour and Employment Practice Group, and he is also one of our leading experts in SAPA. I'll pass over to him and I'll exit left. Get right into it. So today we're talking about the Serious Accidents Punishment Act, and it's timely because the enforcement decree has recently been promulgated in October, and now we are under 2 months for the effective date in January 27th of 2022. So, and that's for companies with 50 or more employees. So let's start first with the background for this new law. So while Korea has undergone rapid economic development, unfortunately, workplace safety has not kept pace with economic development. And as you can see in the chart, Korea right now has the third highest workplace fatality rate among OECD countries. And it's a serious issue, especially for this current administration, which came in with promises of reducing workplace accidents and fatalities. And unfortunately, the opposite has occurred. The workplace accidents and fatalities have continued to increase. And you've all seen in the news a lot of high-profile cases for industrial accidents. So the Icheon warehouse construction site fire resulted in 38 fatalities. At the Taeon thermal power plant accident, a contracted worker was crushed by machinery due to lax safety standards. And even this year, the Kupang warehouse fire, a firefighter was killed trying to put out the blaze. And in addition to the industrial accidents, we've also had some very high-profile public accident fatalities. So you might be aware of the humidifier sanitizer scandal. There are estimates of up to 14,000 deaths resulting from that. And the very public Seoul ferry disaster resulted in over 300 deaths, including many school children. So we've been bombarded by such news in the media against the backdrop of campaign rhetoric and promises to make things better, but things have not gotten better. And therefore, this new law was enacted to make
the top decision makers personally liable so that it could initiate real culture or organizational change in the companies. So, as I said, the legislative goal was to incentivize the top management to take appropriate safety and health measures by holding them personally accountable with serious penalties and criminal charges. And you can see on the timeline, things have happened fairly quickly. So in January of this year, the SAPA was passed. In October, the enforcement decree was promulgated. And then in less than 2 months, in January 27th of 2022, it will become effective for companies with 50 or more employees. And there is a grace period for companies with under 50 employees. You have 2 more years, so it will be January 27, 2024 for companies with under 50 employees. Okay. So that's the background or the why, and now we'll move on to the what, the SAPA framework. And the SAPA is the Serious Accidents Punishment Act. So we'll first go over what the liabilities and the punishment entails. Then we'll cover who will be covered under the SAPA, and then we'll get into some of the nuts and bolts of the SAPA framework. Okay, so for serious industrial accidents, the criminal penalties for an industrial accident that results in 1 or more deaths is imprisonment for 1 year or more, and or a criminal fine up to Korean won 1 billion. For serious accidents, and serious accidents are defined as 2 or more injuries which require treatment of 6 months or more from one accident, or 3 or more patients suffering from occupational diseases from the same cause in 1 year. And the criminal penalties are imprisonment up to 7 years or a criminal fine up to 100 million Korean won. And on top of that, there is vicarious liability for the company, up to Korean won 5 billion fine for deaths, 1 billion Korean won for serious injuries. Okay. So serious public accidents. So in addition to the industrial accidents, the SAPA covers serious public accidents and the criminal penalties for any defect in design, manufacturing, installment, or management of certain ingredients or products, public facilities, or public transportation that results in 1 or more deaths will carry a criminal penalty of imprisonment of 1 year or more, and or a criminal fine up to 1 billion Korean won. And serious public accident injuries are defined as 10 or more injuries requiring treatment of 2 months or more from one accident, or 10 or more patients suffering from disease from the same cause requiring treatment of 3 months or more. And the penalty, again, is imprisonment up to 7 years or a criminal fine up to 100 million Korean won. And there's vicarious liability for the company, up to 5 billion Korean won for death, 1 billion Korean won for serious injury. Okay. And on top of the criminal liability, there's also civil liabilities, and civil liabilities in the form of punitive damages. And in Korea, it's not very common to have punitive damages, but for this law, there is punitive damages up to 5 times actual damages in case of a serious accident that results from willful misconduct or gross negligence in performance of safety and health obligations. So, there are many provisions, there are many ways that the company can be held liable under this new act. And it's not just the penalties themselves, it's also the scope. So prior to the SAPA, criminal liability was much more localized. So under the OSHA regulatory regime, if you had an accident, a serious accident or fatality at the factory, then it would be the head of the factory and the factory EHS manager who would be investigated, and they would check to see if they followed the appropriate safety and health regulations, and if there were any violations there. And then those responsible at the factory would be held responsible. Or let's say there was an accident at the warehouse. In that case, it would be the head of the warehouse and the EHS manager at the warehouse who would be investigated and possibly criminally charged if there was any lapse in their health and safety obligations under relevant regulations. So, it was very localized to where the accident occurred, but the SAPA framework has changed that. So after the new law comes into effect, criminal liability will stay at the top. So regardless of where the accident occurred, if it happened at the factory or at the warehouse, it will be top management of the company that would be held liable for any criminal charges. And it's important to note that this also applies to any third-party workers who provide services at the work site. As long as the company has de facto control over the operation and management of the work site, equipment, and facilities, then it will be the company's responsibility and the company's liability. And this kind of closes a loophole where in the past, outsourced workers, it was the responsibility of the outsourced company if there was any failure in their safety and health management. So that's the punishment and and the scope that it covers. The next big question is who will be held responsible? Okay, so keep in mind that the law was specifically designed to make top management responsible. So the law says a person who represents the business and has the authority and responsibility to manage the business will be held responsible. And in Korea, this is typically the representative director who is registered in the company's corporate registry. There's also a separate interesting provision that says persons with equivalent authority for safety and health related tasks may also be held accountable. And we'll get into the details of that later and see what that might cover. But first we need to answer the CEO's first question, which is it possible for somebody else to be held responsible in case of an accident? So the first scenario we have is, what if we had co-representative directors? So we have the main business representative director, and then the co-representative director who is in charge of safety and health. So as long as the co-representative director in charge of safety and health has the autonomous authority and budget for safety and health matters, it may fulfill the equivalent authority requirement. However, it may not be practical for many companies to concede such responsibility to such a position, and it may not be feasible for the current representative director to lose such significant autonomy over business and budget. So what if we had instead a chief safety and health officer? So let's say there's a chief safety and health officer in charge of safety and health, but reporting to the representative director. In this case, it's less clear if it would fulfill the equivalent authority requirement, and it would depend on the actual level of autonomous authority over personnel and budget for safety and health matters. However, it's quite likely that the current representative director will still be held liable if she exercises final authority over establishing and maintaining safety and health matters. And I guess I should add, you have to understand it in the framework of this law was specifically designed to hold top management responsible. And that's why I think it's going to be very difficult until the tests become more clear to have other than the top management be held responsible. Okay, so now we'll go into a little bit more into the nuts and bolts. So the company has broad obligations to secure safety and health. And Article 4 of the SAPA establishes 4 broad obligations. You'll note that the second and the third points are in case there has been an accident or there has been a government corrective order. So if there has been a prior serious accident, then the company is obligated to establish and implement a plan to prevent any recurrence of such accidents. Or if there has been a prior government improvement or corrective order, then it's imperative for the company to follow such corrective order. And item 1 requires the company to establish and implement an adequate safety and health management system with the appropriate workforce and headcount, budget, and establishing certain health management organizations, standard operating procedures, and you need to have a manual to identify and remedy any workplace safety risks. And then item 4 requires the company to take managerial measures to comply with applicable safety and health laws. And these would include implementing relevant systems or protocols or processes to ensure workplace safety and health. And this includes conducting any relevant inspections, for example, by any third-party independent inspectors, providing relevant trainings to ensure compliance with obligations, and then providing any making sure you are in compliance with the applicable safety and health related laws. And this means also that any safety and health related laws, you need to be aware of what actually applies to you. So ignorance is not going to be an excuse. You need to be aware what laws and regulations apply to you, and you need to have measures in place to comply with such laws. And the main point of taking all of these measures is that if you can show the authorities that you've done the research, you've figured out what laws apply to you, you put the measures and systems in place to deal with any risks, having all of these things will help you to mitigate your liability in case of an accident. And it's impossible, I think, to prevent accidents 100%, but it's very important that you show the authorities that you've taken all reasonable necessary steps to prevent any serious accidents. Okay, so let's go a little bit more in detail on item 1, Article 1 of the item 1 of Article 4. So for establishing and implementing safety and health management systems, the enforcement decree has come up with certain guidelines, and they require you to establish safety and health objectives and policies for the workplace. You have to have guidelines to identify and remedy any hazards or dangers based on the characteristics of the workplace, and you have to monitor compliance at least biannually. You also have to show that you have an adequate budget to procure safety personnel, facilities, equipment, and to remedy any identified hazards or dangers, as well as any other matters if you've been notified by the Ministry of Employment and Labor. You have to have the appropriate number of safety and health personnel, and these would be safety managers, health managers, a chief safety and health officer, and occupational medicine physicians as prescribed under OSHA, and ensure that they have sufficient time to perform their duties. You should also ensure that persons in charge of safety and health have adequate authority and budget to perform their duties, and you have to establish evaluation criteria in order to evaluate the performance at least biannually. You also have to establish procedures to collect employee opinions on safety and health matters and take any necessary measures at least biannually. You should prepare a manual for serious industrial accidents, including response measures such as evacuation, reporting requirements, etc., and relief measures for persons affected by serious accidents, and any measures to prevent further damage. For workplaces with over 500 employees or construction companies ranked in the top 200 in construction capacity, you should establish a separate organization dedicated to management of safety and health matters. And if you're using a service provider for outsourcing, contracting, subcontracting, or worker dispatch, you should establish criteria for evaluating the service provider's capability to prevent accidents and for evaluating the service provider's safety and health management costs. So item 4 requires the company to take managerial measures to comply with applicable safety and health laws. And the enforcement decree of the SAPA provides further details. First, you must inspect compliance with relevant safety and health related laws at least biannually. And in order to be compliant, you have to know which ones are applicable to you. And if there is any non-compliance, you must take appropriate measures. And this includes assigning relevant personnel or providing any additional budgets. In addition, you have to inspect compliance with any mandatory safety and health trainings. So at least biannually, you have to make sure that you are complying with any mandatory safety and health trainings, and then you have to review the results of such trainings. If there's any non-compliance regarding the trainings, you have to take measures to ensure compliance, including providing instructions to provide such training and ensuring that there is a budget sufficient to cover such trainings. So it's overall, it's critical for companies to dedicate sufficient management attention and budget to safety and health issues to make sure that safety and health considerations are properly taken into account in decision-making processes. And it's also important for companies to be aware of their workplace safety and health requirements under the relevant laws to ensure compliance. So this is a so this has been kind of a broad overview. I mean, we can talk a lot about each of the requirements. As yet, it hasn't come into effect, so there are a lot of gray areas. You know, the guidelines are still quite general, even though they, even though there are pages and pages of guidelines. We still don't have any cases that provide guidance. So for this part, we will take questions and try to answer some of your questions related to the new law.
Fantastic. Thank you very much, Anthony. And what you just touched on obviously is quite important to the business community, given that a lot of our members are the decision makers, representatives and directors and CEOs of companies. So obviously these changes to policies are very important, and it's great to see that what you highlighted today and what we should be aware of. So I think we might move now into the Q&A. We do have a couple of questions that have been pre-submitted, so I might kick off to them. If anyone out there has any questions themselves, please be sure to put them into the chat box, and we'll get to them as soon as we can. So the first question I have here, the chamber, for some reference here, does represent a few of the international schools over here. So we've got a question based on that. The question is, does this legislation apply to schools if an incident were to happen on a school excursion, for example, and the teacher or school, would it be potentially liable? And how does the SAPA apply to other registered directors of a company in addition to the CEO?
Okay, tackle the first one first. So it's I guess if the school has more than 50 employees and the incident, first let's start with if the incident happened at school. Okay, and if it happened at school and you have 50 or more employees, then it could be. If you have not followed certain safety and health regulations, let's say there was, let's make an example up. At the foreign school, the fire exits, for some reason, one of the doors was chained or bolted shut and only, was not completely open. And there was a fire, and because of that, a lot of people were injured because they couldn't get out in time. Okay. In that case, if that was a violation of the relevant fire safety codes, then yes, it could apply. It could apply to them for not properly having taken the proper steps for safety and health, and not properly managing the safety and health of the school. On an excursion, I guess it would depend on the facts and circumstances. So it looks like they're going to look at all of the facts and circumstances to see who would be responsible. So let's say it went to like a school-owned camp where the school has control over all the facilities and safety and health. In that case, it could very well be something that the school could be held liable for. If it was, a separate matter, maybe we can look at what happened with the Seoul Ferry incident. It was a school excursion, but let's say the school took necessary measures and checked it had passed. There was no obvious red flag from the ferry about any safety violations, but in fact, the ferry operator was responsible. In that case, it's probably more likely that the ferry operator who was violating the safety and health regulations would be held liable. As long as the teachers in the school, the person in charge, took the necessary precautions and did, there weren't any red flags that they ignored, or there wasn't any negligence on their part. As to whether it applies to other registered directors of a company in addition to the CEO, again, that depends on the facts and circumstances. The law is designed to hold top management responsible, but it could also be, there could also be a case where, if there was a senior level, maybe a registered director who was responsible for safety and health, if the circumstances warrant, they could be, but keep in mind that if the CEO has the final authority on safety and health measures, that it will likely be the CEO in charge.
Yeah, thank you very much. I got a question here from Andrew Wagner. While there is no case precedent, how would the SAPA been applied for recent significant incidents, such as a fire at one of their Korean conglomerates?
Oh, sure. So, it would be investigated in a similar way in terms of, were the proper safety and health standards and requirements under the laws taken? What was the cause of the accident? Was it because of negligence? Was it because of some failure to follow up on their obligations for safety and health? The difference would be that under the current regime, under OSHA, it would be probably limited in focus to the site of the fire, for example. So if it was a warehouse fire, then at the warehouse, whoever was in charge of safety at the warehouse, as well as the head of the warehouse, would be investigated. Whereas under SAPA, it would go all the way to the top, to the CEO as the final decision maker.
Thank you. We've got a question for Philip. Just want to clarify what is considered a director in Korea as many positions out there have the titles have director in them.
Right. So I think for purposes of this act, I think it has to at least, at a minimum, be one of the registered directors. So one of the directors registered in the corporate registry. Even then, it's not sure that it would fall outside of the CEO or the representative director. So out of the directors, there is one or more representative director, and that usually is the person who represents the company.
Yeah. Thank you for clarifying. A question here from Luke. Will the Korean court system be able to deal with the new legislation, seeing that there are many fatal accidents per year? And how long would you expect these court proceedings to take, considering the backlog?
Right. So, that's a good theoretical question, but I think it's a very valid question, because it's a new law, and it's quite serious. It has very serious repercussions for the CEO. So we expect, at least the initial cases will take much longer to go through, for sure. Much longer than normal cases.
Yeah, fantastic. Another question here. Any advice for foreign directors in Korea in case of a fatal accident occurs under their watch? Stay or leave the country ASAP. This is in line with other countries with similar legislation requirements where foreigners are advised to leave as soon as possible.
Okay. So I guess it depends on the facts and circumstances, and probably the individual's personal proclivities as well. But as a general rule, I mean, we should focus on the prevention side. So we should focus on what steps have been taken to be able to defend against any of these charges. So as long as you have taken all the necessary steps, as long as you've taken your obligations seriously, and that you've you're met all of the legal requirements, you've done your safety inspections, you've maybe hired an independent third party to run a safety check. Maybe you've gone through, there's a ISO certification 45001 for safety and health. Maybe you've done that. Anything that you can show the authorities that, look, we've done all that we could to protect the safety and health of our employees. We've done all these things. Then I think probably it would be at least a mitigation of the punishment, because you can't prevent 100% prevent any accidents from occurring by its nature, but at least you have to be able to show that you've taken as many steps as possible. And if you haven't, then maybe you might have to take that other option.
Fantastic. Well, I think we might leave it at that. If there's any other further questions from our audience, please be sure to contact AustCham Korea. We'd be more than happy to connect you with Anthony or Michael, who might be able to answer those questions more in detail. But in wrapping up today's session, I would sincerely like to thank our silver sponsor, Shin Kim, for not only supporting the business community, but also for co-hosting today's webinar. Thank you, Anthony Chang and Michael, for your presence today. I'm sure we look forward to seeing you soon. So thank you very much, and look forward to speaking to everyone soon. Thank you.
Thank you.